As a criminal defense lawyer, if someone comes in and they're saying, okay, look, I've just got caught, I don't know, I had like 2 kilos cocaine or whatever it is, right? Whatever the offense is, they come in here and then they say this to you, right? And they say, but I want to plead not guilty, right? So they admit to you, like, I've done X, Y, Z, right? So would your advice then be to say, okay, look, you should plead guilty to that, but let's try to make sure that, it's minimum, we don't, it doesn't get kind of too convoluted and stuff like that? Or do you try to go for that not guilty with them?
A phrase I commonly use is, just because you did it, it doesn't mean you're guilty. What I mean by that is, you may have done something, but you are probably not guilty in law. Let me tell you why. Because there's 2 elements that needs to be satisfied for you to be guilty of an offense. The first one is mens rea, the mental element. The second one is actus reus, the action taking place. Yeah? So if you've been caught with a couple of kilos of cocaine in your boot, but you don't know they're in the boot, you're not guilty of the offense. Okay? If you've punched somebody and they've got a bad injury, but you've done it in self-defense, you're not guilty. So there are times that people do come and they say, I want to plead guilty, and that's their choice. I can't force anybody to plead not guilty. I point out what the prosecution need to prove, and I put that on the table. And if they think that they can have a trial, they do have a trial. Somebody wants to plead guilty, be my guest. I'm not going to force you to plead not guilty. Even if somebody admits the guilt to me, they can still have a trial. But we can't put forward a defense at court. We can't advise the client to go and take the stand and give evidence in court, talk in court. That's called giving evidence. We can't advise the client to do that. So my advice in those circumstances, if somebody still wants to have a trial after admitting the guilt to me, will be, okay, we'll put the prosecution to strict proof. And which means basically, in criminal cases, the burden of proof is on the prosecution. This is legal jargon now. The burden of the proof is on the prosecution. They have to prove, they have to make the jury sure. They have to be sure. Which means...
So the one who's accusing needs to prove, okay?
Yes.
Okay.
The prosecution need to prove it. We don't need to disprove nothing. So the jury have to be sure. Sure means 100%. They can't be 99% sure. And the defense version, just say, would only might have to be true for the jury. Or if the jury think it might be true, we don't 100% believe it, but it might be true. They have to acquit. So it's the prosecution's job to prove a case against you. So the answer to your question is, if somebody admits the crime to me, they can still have a trial. Or I can say to them, sometimes the evidence is overwhelming, so I'm not going to advise no one. Because it's people's lives. It is people's lives. But people sometimes mind now, when I tell them, listen, you should go guilty, but they say, there's meant to be a defense for every offense. I tell them, I go, look, the jury are not blind. They're normal people. They're normal. They don't get blind people on the jury. No disrespect to blind people. But the jury have to visualize. The jury have to visualize the whole trial, what the prosecution is saying, what the defense is saying, what the client is saying, what the judge is saying, then make a decision. So jury are not stupid. They're not going to believe anything you tell them. Your arguments have to be convincing. So when, alhamdulillah, I've got a lot of good results. I'm not just boasting. Don't listen to me. Check the history. Check whatever you want to speak to who you want. I've got a lot of good results and I've got a lot of acquittals. People think I've done something dodgy or something. No, it just means the prosecution was not able to prove it.